Hey everyone, Jose Almanzar here. I'm an environmental attorney with Holland and Knight, and thank you for joining us for this afternoon. It's a fantastic program, and I think we're going to dive right in. We have a lot to cover. So in 2020, 16 young people between the ages of 2 and 18 years old from Montana filed a lawsuit against a state law claiming their lives and liberties were at stake, and that their constitutional rights to a clean and healthy environment were at risk. They were challenging a Montana law that allowed the state agencies to turn a blind eye to climate impacts of government decisions. The young plaintiffs brought this suit under Montana constitutional law, specifically the state's Green Amendment, which protects the right to a clean and healthful environment. These plaintiffs filed the suit not just on their own behalf, but also on behalf of future generations. And for at least a decade, young people across the United States have turned to courts to challenge their rights and asking their states and state governments to step up and consider the impacts of climate change on government decision-making. And year after year, courts have been reluctant to hear these cases, usually denying plaintiffs on legal theories such as standing and other complex public policy grounds. That is, until a few months ago, on August 14th, 2023, when Judge Kacy in the First Judicial District Court of Montana ruled wholly in favor of those 16 plaintiffs in Held v. State of Montana. And that Judge Seeley, relied on the state's Green Amendment. This is the first time a Green Amendment was ever successfully applied in a climate change case. This is the power of the Green Amendment, and this is the power of elevating the environment to be protected under constitutional rights. For the next 60 minutes, we'll explore the concept of a Green Amendment and what it means for the national climate change movement. We will do a semi-deep dive into the Held versus Montana case and where it stands today. And then we're going to engage in a roundtable type of forum discussion with my distinguished panel. First, I'm going to introduce two panelists, and then later on I'll introduce the rest. But to get us going, we're going to speak first with Maya Van Rossum. And Maya's going to speak to us about the Green Amendment, and she's probably no better person to speak about the Green Amendment because she's the founder of the Green Amendment National Movement, and she founded the nonprofit organization Green Amendments for the Generations. Maya has authored 2 books on the Green Amendment, has given countless lectures on the topic, and it's a pleasure to really be here with and discuss where she stands today as a Delaware Riverkeeper and as a big proponent of the National Green Amendment movement. Good to see you, Maya.
Good to see you.
And after Maya, we're going to go into the Held versus Montana case, and leading us in that charge is none other than Michael Gerrard. Michael is a longtime friend of mine and also happens to be a really fantastic person. Michael is the Andrew Sabin Professor of Professional Practice at Columbia Law School, and he teaches courses on environmental law, energy law, and policy. He also founded the school's Distinguished Sabin Center for Climate Change Law. Michael has authored too many environmental books to count, and has lectured on just about every environmental topic under the sun. So I'm not going to belabor that point. If you don't know Michael, then you probably aren't doing enough homework on environmental law. Michael, good to see you.
Good to be with you, Jose.
All right, so as I mentioned, we have 2 other panels, but I'll turn to them once we get to the roundtable forum discussion. Maya, why don't we just dive into it? Why don't you take us through the Green Amendment and your thoughts on where the movement stands today?
Great. Well, thank you so much for that kind introduction. It really is wonderful and exciting to be here today to talk about the Green Amendment movement, to talk about where the movement stands, how it's growing and progressing, and the powerful positive benefits that are coming out of the Held v. Montana case that, of course, was victorious just over a month ago. So I thought that I would start by really diving into what a Green Amendment actually is to lay that foundation and framework before Professor Gerrard talks about the Held v. Montana case. People always ask me, my role as an environmental activist, what is it that we should be doing when it comes to addressing the climate crisis? And, my answer is we need to keep doing everything that we're already doing. We need to double down on it and do more of it. But one thing that we really need to add to the palette of work that many people don't immediately think of is we really need to transform our system of law and governance when it comes to environmental protection here in the United States of America. We need to reorient government action and decision-making so it's focused on prevention of pollution, degradation, and harm in the first place. It doesn't just accept environmental desecration as a foregone conclusion and hop to the end of the process and say, okay, what permits are we going to issue to manage that harm and to literally legalize it? We also need to transform the system to ensure that people have a meaningful place at the table throughout the entirety of the governing process, no matter who's governing, whether it's a legislature or a local government, municipal council. We need to ensure that when people experience transgressions onto their inalienable human right to a clean, safe, and healthy environment, that they have an opportunity to do something about it and to hold government accountable and to change the trajectory of what's happening. And that's really what, to me, green amendments are. Green amendments bring forth that transformational change to our system of laws and governance when it comes to environmental protection. Quite simply, what a green amendment do is it lifts up the inalienable human right of all people to things like pure water, clean air, a safe climate, and healthy environments, and gives them highest constitutional standing, recognition, and protection, placing them on par with all of those other fundamental human rights that we hold dear, things like the right to free speech and freedom of religion, for example. Now, if you want to get highest constitutional recognition for environmental rights, not just any language anywhere within the Constitution will do. There are essential criteria that need to be met along with critical placement to ensure this highest level recognition and protection. And one of the reasons why we know that is because, quite honestly, almost every state across our nation in their constitution talks about environmental protection, and many of them even talk about environmental rights. But only 3 states do it in such a way that environmental rights are given highest constitutional recognition and enforceability and apply to all government action in the state. Those 3 states are Pennsylvania, Montana, and most recently, the state of New York passed a green amendment. So what is a green amendment? What are the essential criteria necessary to accomplish this highest level of recognition and protection? Well, first and foremost, the language has to be placed in the Bill of Rights or the Declaration of Rights section of the Constitution. That's where we place all of the other human, civil, and political rights we hold dear. If we want our environmental rights to have that same highest constitutional protection and standing, we need our environmental rights placed in that same section of the Constitution. And Bill of Rights placement doesn't just mean that the language is physically higher up in the Constitution. There are actually meaningful, substantive, and procedural obligations that come into play in defense of these environmental rights because of that Bill of Rights placement. So we want those for environmental rights, and we need those we therefore need that Bill of Rights placement. The language needs to be clear that we are protecting the rights of all people. And it needs to be clear what we're protecting things like clean water and clean air, safe climate, healthy ecosystems, and environments. The language needs to clearly apply to all levels of government and all government officials. It cannot simply apply to the state legislature. We have to ensure that the legislature, the local town council, the governor's office, the attorney general's office, all the regulatory agencies are constitutionally bound to protect the environmental rights enumerated in the Green Amendment in order to ensure that it has the fullest level of protection throughout the governing process. The language needs to be self-executing, meaning that it's enforceable in its own right. If you can't find a piece of legislation that will properly protect your right to clean water or a safe climate, you can turn to your constitutional right to clean water and air, a safe climate, and healthy environments to bring the necessary legal action to enforce those fundamental human rights that we all hold dear. And the language needs to be enforceable by the people. You don't need to have to find some permission in some statute that allows you to enforce against an infringement on your environmental rights as enumerated in the Constitution. With proper Green Amendment language, it's clear that the language is enforceable by the people. Now, those are must-haves in terms of essential criteria, but they're also value-added provisions that really bring clarity and strength to a Green Amendment. First off, all Green Amendment language, because of the carefully chosen language that we use in a Green Amendment, along with that Bill of Rights placement, all Green Amendments lift up and strengthen and empower environmental justice and environmental protections and ensure an obligation to equitably protect environmental rights and natural resources for all people, regardless of race, ethnicity, wealth, gender, or geography. But I think it's over time, what I've come to experience and learn is that rather than having to explain the environmental justice power of a Green Amendment, it's really best to just say it in the language. So now all of the best Green Amendment proposals advancing right now explicitly say it. These environmental rights belong to all the people and must be protected equitably, regardless of race, ethnicity, tribal membership status, gender, geography, or wealth, or some iteration thereof. Generational language in a Green Amendment is also powerfully helpful and important. It ensures that government must be planning and thinking about and governing for the long term, that it's assessing and bringing into its decision-making consideration of cumulative impacts over time and over space and over generations. We've proven in the Commonwealth of Pennsylvania that this obligation to protect natural resources and environmental rights for future generations isn't just pretty aspirational language. It is actually substantive, meaningful, and enforceable. And it's also incredibly valuable to identify the state as the trustee of the state's natural resources with an obligation to protect those natural resources for the benefit of the people who are identified as the beneficiaries of the trust being the natural resources of the state. Trust law brings an incredible level of clarity and guidance to what it actually means to have to protect natural resources for the benefit of all people when it's included in Green Amendment language. There are clearly laid out obligations, fiduciary obligations of trustees. Among them is that they have to prioritize the protection of the corpus of the trust, in this case, natural resources, for the benefit of the beneficiaries, in this case, the people. They can't be prioritizing, private business profits or political agendas over what is best for the people when you have this kind of trustee language. And when you include all of those elements, you really do lift up the rights to clean water, clean air, a safe climate, and healthy environments. So they are given the same most powerful protection as those other fundamental rights we hold dear. We all know how powerfully the right to free speech and freedom of religion are protected because of the language and the Bill of Rights placement. This same power now comes to bear for the environment when you have a Green Amendment in your state constitution. And I guess I should have started there. We're really focused on state constitutions first, getting a Green Amendment in every single state constitution across our nation. And we will, when we reach the right tipping point, also be seeking to secure a federal Green Amendment because we really need them at both levels of government. So what are the kinds of things that states who have language but don't have Green Amendments, what are the kinds of things that they do? And I'm just thought I'd pull a few examples. First off, they might talk about environmental protection or environmental rights, but they place it not in the Bill of Rights section of the Constitution. They place it lower down, for example, in the miscellaneous section, where it doesn't get the power and the benefit of the substantive and procedural obligations that Bill of Rights placement gives you. Or they might talk about, environmental rights or natural resources protection with very lovely language, but they declare it to be the policy of the state. Policy is essentially good advice. You can take it or you can leave it. It's not really substantively enforceable in the way a clear obligation is. They might again have nice language about natural resource protection obligations and environmental rights, but then they hand it to the legislature to decide and define what that actually means. The ramification is you haven't actually created a right of the people. You've really created a duty on legislators to legislate with regards to the environment. And even if they do so badly, it can be upheld in the courts because the people don't have that enforceable that enforceable constitutional right that they can use to challenge whatever that bad government action is. Often the language will be focused on pollution control rather than environmental rights. They're fundamentally different concepts. A right to clean water is different than an obligation on your government officials to manage pollution and manage despoilment of the environment. And then finally, we do see language in the Declaration of Rights section of our state constitutions, but it's focused on other things like the right to fish, hunt, and trap, which are certainly important values for many states and communities, but again, is fundamentally different than the right to things like clean water and safe climate. Now, at this point, as I said, we have green amendments in 3 states, Pennsylvania, Montana, and New York. But more and more states are coming on board with the Green Amendments for the Generations movement to advance this kind of critical transformational protection. There are Green Amendment proposals already put forth in 14 states nationwide, with more states coming on board all the time. They're getting organized and they're getting in touch to pursue this powerful pathway. Now, what do we do when somebody gets in touch and wants to have a green amendment? Well, we certainly go in with model language, with all of the bells and whistles of best protection that a green amendment can have. But we then work with the community and work with legislators to characterize or recast this language so it best suits the personalities, priorities, and goals of that particular state. This is not cookie cutter stuff. The same language will not work in every state, right? We have to make sure we're advancing Green Amendment language that's right for that state, its priorities, its unique qualities, and again, its personality. Let's take a look at the 3 states that have Green Amendment language really quickly. Pennsylvania, Article 1, the Declaration of Rights section of the Constitution protects the rights of all people to clean air, pure water, and healthy environments. It has that key generational language, and it identifies the state as the trustee of the state's natural resources for the benefit of the people. This language has proven very powerful in Commonwealth courts. Montana does it a little bit differently, a little bit more limited language in the Bill of Rights section or Declaration of Rights section of the Constitution. All persons have a right to a clean and healthful environment, but there's additional robust language lower down in the Constitution that the state Supreme Court has sort of bootstrapped up in order to help inform what it means to have this constitutional entitlement to a clean and healthful environment. And then New York just decided to go much more direct and just say each person shall have a right to clean water and air and a healthful environment. This language is proving powerful in terms of environmental rights protection. Its interpretation is being informed by what has happened or come before in Pennsylvania and Montana. But the decision not to include some of the other elements I talked about means that there's going to have to be more activity in the courts when issues regarding things like generational protection come up. So if you want to learn more about the Green Amendment movement or what might be happening in your state, the website is forthegenerations.org. Or you can also get the book. And because you join this forum and because of a generous benefactor, if you type in the code HELD while ordering the book, you can get the book just for $10 and shipping is free. And again, that's because somebody very, very generous wanted to make this book broadly available to all of you who attended today's forum. So with that, I thank you for the time and I turn it back to Jose.
Thank you, Maya. And I should add, I'm not just saying this because Maya is a good friend of mine and I think everyone should buy the book. It's really well written. And it tells a wonderful story of somebody that has demonstrated a career passion for the environment and has found the legal tools, or at least a legal tool that might be able to get us out of this disaster that we've been in. So Maya, I wish that promo code was available when I bought the books, but I'm happy to contribute when I can. Now, Professor Gerrard, if you can spend a little bit of time on the Held versus Montana case and give us kind of some of your knowledge and your view of how this case might impact the Green Amendment movement and the climate change movement nationally and potentially globally.
Great. Thanks very much, Jose. So as you heard, the Montana Constitution was amended in 1972 to state that, quote, all persons have certain inalienable rights, including the right to a clean and healthful environment. And that, again, quoting, the state and each person shall maintain and improve a clean and healthful environment in Montana for present and future generations. So the Held versus Montana suit was filed in March 2020 in Montana State Court, based largely on these provisions of the state constitution. As Jose said, it was brought by 16 young people who then were aged 2 to 18 against the state and its governor and state agencies. The case challenged the constitutionality of Montana's state energy policy, which explicitly favors fossil fuels, and the section of the Montana Environmental Policy Act, their equivalent of NEPA, that bars state officials from even considering climate change and making energy decisions. The plaintiffs alleged that anthropogenic greenhouse gas emissions were already triggering a host of adverse consequences in Montana, including dangerously increasing temperatures, changing precipitation patterns, increasing droughts and other extreme events, wildfires, glacial melt, and so forth, and that the state had continued to act affirmatively to exacerbate the climate crisis, despite their awareness that the plaintiffs were living under dangerous climatic conditions that create an unreasonable risk of harm. The plaintiffs sought a declaration from the court of their right to a clean and healthful environment, a declaration that the state energy policy and the bar on considering climate change and decision-making were unconstitutional. And they sought injunctive relief in the form of orders directing the state to prepare an accounting of the state's greenhouse gas emissions and develop and implement a remedial plan to reduce emissions. The state moved to dismiss the case. In August of 2021, Judge Kacy granted the motion to dismiss it in part and denied it in part. The judge found that the defendants had standing to assert their claims that state policies violated the state constitution and the public trust doctrine, and that the plaintiffs could pursue their request for declaratory relief. But Judge Seeley said that injunctive relief, ordering a remedial plan, would violate the political question doctrine. After some motion and promotion practice and discovery and an exchange of expert reports, Judge Seeley set a trial date for June of 2023. The state legislature, in an apparent effort to prevent the trial, repealed the state energy policy that encouraged fossil fuel use. But the law that prohibited state officials from considering climate change when making energy decisions was still on the books. And so Judge Seeley then ruled that because that part of the law was still there, the trial could go forward. The state then went twice to the Montana Supreme Court, asking them to stay the trial. The first time the court ruled for the plaintiffs by a vote of 6-1. The second time it was 5 votes for the plaintiff with 2 judges not voting. So the trial began on June 12th. It was scheduled for 2 weeks, with the plaintiffs presenting the case the first week and the state having the second week, but the state ended up taking only less than 2 days. Several of the young people who had brought the lawsuit testified. They were all Montana residents, and they all talked about how the impacts of climate change are already impairing their lives. For some, it was making their asthma worse. For some, it harmed their family farms and ranches. For others, it inhibited their fishing or their outdoor athletic and sporting activities, or caused them great anxiety. The plaintiffs had several scientific witnesses. They had Dr. Stephen Running of the University of Montana, who's a leading climate scientist and a member of the IPCC team that won the Nobel Peace Prize in 2007. He talked about how greenhouse gas emissions are causing global climate change and harming Montana's ecosystems and hydrology. And another leading climate scientist who talked about how climate change is already and projected to affect the ecosystems of the state. They had a Montana pediatrician who testified about how climate change harms the health of children. A clinical psychiatrist testified about the psychological harm that climate does to children. Michael Durglow Jr., a member of the Confederated Salish and Kootenai tribes, talked about the effect of climate change on their cultural heritage. A research scientist, retired research scientist from the Geological Survey, talked about how climate change is harming the Glacier National Park. Another expert talked about the effect of climate change on the state's water resources. And finally, Dr. Mark Jacobson, a well-known engineering professor at Stanford, testified about how energy systems can be transitioned away from fossil fuels to clean energy sources. The state's cross-examination of these scientific experts was very brief and didn't really undermine any of their testimony. The state had indicated that it planned to call a scientific witness who would testify that while climate change is real, it's not really that bad, but they decided at the end not to call her. They did call 2 state energy officials who confirmed that they are prohibited from considering climate change in their decision-making on energy policy. The state put on an economist who talks about global and state greenhouse gas emissions. The plaintiff's lawyers brought forth several errors in his work, and the court found that the state witness's testimony, quote, was not well supported, contained errors, and was not given weight by the court. So in the end, the state used less than 2 days for its direct testimony. Judge Seeley issued her 103-page decision on August 14th, my birthday. So it was a nice gift. She found that the youth plaintiffs had standing to sue because they showed they were personally affected by climate change. She found that the plaintiffs have proven that the state's disregard of greenhouse gas emissions and climate change contributed to the emissions that are worsening climate change, and the state has the discretion and the ability to lower fossil fuel extraction and combustion. She found that Montana, due to its coal mines and oil and gas productions, is a major emitter of greenhouse gases in absolute terms, in per capita terms, and historically. Judge Seeley ruled that, quote, there is overwhelming scientific consensus that Earth is warming as a direct result of human greenhouse gas emissions, primarily from the burning of fossil fuels, that the cumulative effect of greenhouse gas emissions causes the impacts being experienced today, and that human activity in the burning of fossil fuels accelerated the accumulation of CO2 to the point that 42% of the total accumulation of CO2 atmosphere emissions has happened in the last 30 years. She found that so long as greenhouse gas emissions stay at high levels, the Earth will keep getting warmer, and the climate impacts we're already seeing, wildfires, drought, sea level rise, extreme heat, will keep getting worse. The court went on to declare that every ton of fossil fuel emissions contributed to global warming and impacts to the climate, and Montana is responsible for a lot of the fossil fuel from the extraction of coal, oil, and natural gas. So Judge Seeley found that Montana's children have a fundamental right to a clean and healthful environment, and that the state has an affirmative duty to take active steps to protect that right. She declared that the state law that bars consideration of climate change in its energy decisions violates the state constitution. And she also gave the plaintiffs the ability to apply to recover their attorney's fees and costs from the state. The state indicated that it will appeal the ruling in the state Supreme Court, and in fact, this morning they filed their formal notice of appeal. So Held versus Montana was one of about 25 lawsuits brought around the US by Our Children's Trust, a nonprofit organization based in Oregon, except for a case in Hawaii that you'll hear about, and one in Pennsylvania. The Held case in Montana was the only one brought under an environmental rights provision of a state constitution. This was the first case brought by youth plaintiffs to go to trial. In fact, it is only the second trial ever in the United States, and so far as I know in the world, where climate scientists took the stand, were placed under oath, and subjected to cross-examination. The first one in Vermont back in 2007, the side favoring climate action also won. So we have in Held versus Montana a resounding decision from a court that climate science is sound, that climate change is caused mostly by fossil fuel combustion, that it's already causing negative health and environmental impacts, and those will only get worse until we stop using fossil fuels, and that all of this violates the right established by a Green Amendment, and young people have a right to go to court to get relief. So that's my summary of the case.
Thank you, Michael. I'm going to ask you an unfair question. Who's going to win this appeal?
Well, the plaintiffs did go, I'm sorry, the state twice went to the state Supreme Court to try to stop the trial. And in both cases, the state Supreme Court resoundingly said no. So I would say that with the current composition of the court, I am cautiously optimistic.
All right. Thank you so much for that. And everyone, you can look up Professor Gerrard and follow his Sabin Climate Center at Columbia Law for all things climate related. And now I'm going to introduce the rest of our panel, and we're going to dive right into our forum. So first, I want to introduce everyone to Ivonne Norman. Miss Norman, as I call her, Ivonne, she's a civil litigator and an environmental justice advocate in New York. And she's a nonprofit board leader and very active with We Act for Environmental Justice. Ivonne has authored articles on extreme heat, has spoken on panels on environmental justice issues, including the Green Amendment, and she currently co-chairs the Environmental Justice Committee for the New York State Bar Association's Environmental and Energy Law section. Ivonne, thank you so much for being here, and happy to have you.
Thank you, Jose, for that warm introduction. And I must add that my co-chair of the EJ committee is Mr. Jose Almanzar.
Oh, well, I was hiding the lead there. And finally, I want to introduce Kacy Manahan. Kacy joined the Delaware Riverkeeper Network as a staff attorney in 2020, and her work focuses on challenges to natural gas drilling and infrastructure work, federal permitting challenges, and state environmental and land use law. Prior to joining the Delaware Riverkeeper Network, Kacy practiced environmental law at a private boutique firm in New Jersey. Kacy obtained her Bachelor of Arts from Ursinus College in Collegeville, Pennsylvania, and she's licensed to practice law in New Jersey and Pennsylvania. Hi, Kacy, good to see you.
Hi, Jose, thank you so much.
So, Ivonne and Kacy, I'm going to ask both of you kind of a leading question. You heard Michael, myself, and Maya speak about the importance of the Green Amendment. So what are your thoughts on this? And maybe, Ivonne, if you want to take the first shot at it.
Yeah, sure. Thank you. It's really exciting to be here. And I just thank you for everyone who's joining us this afternoon on these incredible efforts. Yeah, Jose, when I think of Green Amendments, what immediately comes to mind is the fact that our lives literally depend on clean air, clean water, and a healthy environment and a stable climate, which are precisely the rights that are sought to be protected with a Green Amendment. These rights have been taken for granted for much too long. And now we find ourselves as the nation in a difficult position to try to undo the harm that has been done for decades to our natural resources by industries that have put profits before the health of the community and the protection of nature. So I believe it is very important and long overdue for the entire nation to elevate those rights to clean water, clean air, a healthy environment, and a stable climate to the status of a constitutional protection. And this is why we're all here today.
Awesome, thank you. And Kacy, what are your thoughts?
So very, very similar reasons to Yvonne's. I mean, the Green Amendments are important because for too long, our state governments and our federal government have kind of seen their role as a facilitator of commerce, regardless of external costs that result from that commerce, like fossil fuel pollution, for example. And in the 1960s and the 1970s, when there was this environmental awakening, you know, many of us have heard of the book Silent Spring, and, you know, that's when most of the major environmental statutes were passed. That did help raise awareness and score some big points and big political wins for people and the environment. But since then, those wins have been somewhat eroded through regulation and legislation that favors polluters, because those polluters have outsized access to our leaders and our political, our legislators. So many environmental statutes now are seen almost as a box checking exercise by the regulators. And they often foster a narrow view of environmental impacts from the perspective of the permittee rather than the people who have to deal with the pollution. And so the fact that a Green Amendment is a constitutional provision really flips the script, because the Constitution tells the government what it is and what it is not authorized to do. It's the instruction manual for any government. So when the Green Amendments prioritize life, they shine light on the blind spots of the current regulatory framework of environmental protection.
That very well put, Kacy, and I think it's important for everyone to understand that the constitutional rights, when a government acts to amend its constitution, it's doing the will in a very literal way, doing the will of the people. So it's thank you. I couldn't have said that better myself, Kacy. Maya, I do have a question for you. Is this the first time in your history of this movement that this Green Amendment has been used and to protect the environment generally, or used in this way?
So as Professor Gerrard pointed out, I think this is really the first time that a Green Amendment language has been used to focus on the climate and arguments around the climate and climate crisis and climate science. And that's really powerful and important, and is going to help us make progress in how Green Amendments are used, or how they're interpreted and used moving forward. But this is definitely not the first time that Green Amendment language has been used to powerful effect for protecting the environment and for protecting communities. I do want to acknowledge Pennsylvania's Green Amendment was passed in 1971 and Montana's in 1972, but neither one of them really got traction or meaningful use until several decades later, which was a couple of decades ago. But since that time, since both of them really started to get that powerful traction, we've had some really powerful cases. For example, in the Commonwealth of Pennsylvania in 2013, there was a very pro-fracking, pro-industry law that was passed by the Pennsylvania legislature that put in place automatic waivers from environmental protection standards for the industry and mandated that fracking operations be allowed to be located as close as 300 feet from people's homes, from hospitals, from schools, from playgrounds, right in the heart of residential communities. We were able, and this was the first time where Pennsylvania's Green Amendment was used to meaningful effect, we were able to use Pennsylvania's Green Amendment to actually defeat those pro-fracking aspects of the law. And they were literally carved out and never allowed to take effect. In Montana, there have been two different situations about a decade apart, but or a couple of decades apart, where the state gave permitting to industrial gold mining operations in critical ecological areas, one of them just outside of Yellowstone National Park. And if those operations had been allowed to advance in either scenario, it would have had significant impacts on the environment, on communities, on waterways, and on ecotourism that depends on healthy environments. Because of Montana's Green Amendment, in those two separate situations for different reasons, those permits were actually voided. And those projects ended up never going forward. In Pennsylvania, we've used the Green Amendment in order to secure cleanup of a long ignored toxic site, a supersaturated site that was ignored for over 3 decades. And rather than clean up that site, the state of Pennsylvania negotiated a sweetheart deal with the developer that would have allowed that site to be developed in its toxic condition. Because of the Green Amendment, we've stopped that development progress, and we've now secured meaningful action by the state to clean up that site. And I want to acknowledge in New York's Green Amendment's less than 2 years old, and it is already being effectively used by a community that's been burdened by a large scale and growing landfill. and they've been impacted by emissions from the landfill, hazardous air emissions, greenhouse gas emissions. And for years, when they'd asked the State Department of Environmental Conservation to stop allowing the landfill to expand and operate in these harmful ways, they were ignored. After the Green Amendment was passed in New York, and the state took more action to allow the continuing operations of this landfill in these harmful ways, the residents were able to grab hold of their new constitutional right to clean water and air and a healthful environment and actually challenge what the state was doing, and got a really powerful first victory with the New York Green Amendment that now is holding government accountable to protect those communities. And very finally, right, not all Green Amendment progress is about legal challenges to stop bad things. So to stop bad things, ideally, Green Amendments advance good things. And so we've had several scenarios where government has taken on good government action to proactively protect the environment. In one situation, it was an urbanizing community that used the amendment as a cornerstone of a decision to reject a development project that would have decimated the last remaining piece of green space in the community, where there was an old growth forest and a high quality stream. That land, those natural landscapes are now preserved. And Pennsylvania and Montana, in entirely different ways, both positively use their respective green amendments to actually protect drinking water supplies. In Pennsylvania, it was to put forth some of the strongest PFAS protections for drinking water that we've now seen in the nation. So that's the ideal. We get good government decisions that avoid legal action, but when legal action is necessary, the people have been able to use their green amendments in really effective and powerful ways.
Thank you for that, Maya. And I want to kind of highlight something that I think we take for granted, but you kind of shine a light on this, to borrow a term that Kacy used in your book, your first book, I believe, where you lay out in very clear terms the fact that our current environmental regulatory scheme nationally from top down is one of permissive environmental degradation. So to the extent that developers, industries, applicants can obtain permits, they are allowed to pollute the air, the water, the land, as long as they emit or release or discharge pollutants under regulatory levels. And that's one of the things that I think this Green Amendment movement will challenge, is that even in instances where I'll call them polluters, but industry is discharging beneath certain regulatory limits, people will still have the right to challenge the government approval of certain permits if they feel that their constitutional rights are being violated. So no longer, at least in many of these states, no longer is it a defense to say that you're within your permit limits. The permit scheme might be flawed. So I think that was something that I felt compelled to highlight. So Maya, thank you for that. And Kacy, I have a question for you. So as we know, climate change and the climate issues that we're facing are not isolated to the United States. It's a global problem. So how, in your view, how can the Green Amendments movement on a state level be used to enforce the right to a safe climate beyond state borders?
Sure. So, I mean, we know one of the most pernicious characteristics of climate change is that there are so many sources of greenhouse gases, both large and small, both private and governmental, both intentional and unintentional. And there's a debate, I think, in the environmental space about whether we as individuals have any responsibility to alter our behavior, like should I ride my bike to work instead of drive, or whether it's all just massive companies who need to be shut down as soon as possible, and then all of our problems will be solved. But the truth is that all sources of greenhouse gases contribute to climate change, and any action to reduce emissions helps to secure the right for a safe climate for everyone. So what a Green Amendment does is focus on the actions of state government in all branches and in all levels, prohibiting state action or inaction that infringes on the rights enumerated. So that's powerful in and of itself. But when you think about the role of states as laboratories of democracy, it's very exciting to think about how green amendments could drive trends in government decision making that carry over to states and to other governments, even outside of the United States, that may not even have green amendments. So long story short, a single state with a green amendment can't solve climate change, but neither can any single actor on the planet. So solving climate change requires billions of good decisions, both large and small.
Yeah, and I agree with that, and if I could just throw in that we are seeing emerging around the world decisions from quite a few courts saying that their national constitutions or other legal doctrines of those countries also require action to fight climate change. The most prominent of those was a decision from the Netherlands, from the Supreme Court of the Netherlands, but we've now had decisions from Germany, from France, from Pakistan, from Nepal, from Brazil, from Colombia, from several other countries, and this number is increasing every year, saying that there is either a constitutional right or a right under human rights treaties that these countries have signed on to a stable climate system. It's not only in the U.S. This is really spreading around the world.
Thank you for that, Professor Gerrard, and thank you, Kacy, for that. I'm going to pivot now to kind of some more procedural aspect of this. So, Ivonne, I'll ask you bluntly: wouldn't it be easier just to pass legislation to address a climate crisis, or do you feel that a green amendment is still the best way path? Because as advocates have to acknowledge, resources are limited, time is limited, and lobbying power can get diluted if you don't put it into the right place. So what are your thoughts on that?
Yeah, sure. Thanks, Jose. So I think this is the perfect segue into it. But there is a significant difference between a constitutional amendment and a piece of legislation. A constitutional green amendment carries force and permanency, whereas legislation is much more limited in what it can accomplish. And in certain situations, it can be repealed. But most importantly, state statutes are generally focused on a specific aspect of the environmental impact. So for example, water or air or the ecosystem. And as a result, there may still be gaps or blind spots in environmental protection, as Kacy has aptly described it. And in situations where there is, for example, a unique project or a unique community or specific site conditions or cumulative impacts from other operations, the project will likely result in significant harm to that community or the natural resources that the legislation did not anticipate. In those situations is when the Green Amendment can help empower the governmental agency and can provide the people of the state with a powerful tool to address those unanticipated or unaddressed consequences. So even if the process to pass legislation may appear on its face to be easier, it will unlikely ever offer the comprehensive protections that are guaranteed under a Green Amendment. And therefore, that's why this movement is so important and crucial at this point.
That's a great point, because we're seeing other constitutional provisions in the Bill of Rights being utilized to fill the gaps, in a sense, where states either haven't acted or have gone beyond their police powers. So thank you for that. I want to pivot now to a question to Maya and Kacy. We've seen challenges to the green amendments popping up in many states, certainly in states where green amendments are being proposed, but also just across the country where there are strong forces that are opposing to green amendments. What are some of the common themes that you're seeing, or common topics that are being raised for parties that are opposing green amendments? And maybe we could start with Maya.
Sure. So I'm going to talk about it from the perspective of when language is proposed. What are we hearing from the opposition? And the interesting thing is, in all of these 14, 15 states, the opposition pretty much has the same talking points. So I'm going to go through the highlights. First one is, this language is too broad. What is clean water? What is clean air? Really missing the point of a constitutional fundamental right, which is to give that broad language that gives the overarching guidance to ensure that all government action is being advanced through that lens of fulfilling the right that is being protected, right? And the truth is, Bill of Rights language is always broad, right? We have a right to free speech, to be free from unreasonable searches and seizures, to peaceably assemble. What's unreasonable? What's peaceable? What is free? So broad language is by design in the Bill of Rights section. And that's because we need to be able to cover all the issues, right? Both in space and time, as well as unanticipated advancements when it comes to the issue at play, in this case, when it comes to the environment, right? Decades ago, people weren't talking about fracking. You need a fundamental right that would be able to cover that kind of unforeseen issue. So broad language, easy to answer. Broad language exists in all Bill of Rights provisions. It's by design. They say that there's going to be this massive onslaught of litigation. Holy crow, all this frivolous litigation where the whole world's going to stop. Well, first off, when it comes, number one, we're not seeing that. In any of the 3 Green Amendment states, we are not seeing an onslaught of litigation. We have seen zero frivolous lawsuits brought based on Green Amendments. And that's in part because, lawyers are responsible, and there are ramifications for pursuing frivolous lawsuits. They can be subject to sanctions and fines. They lose their reputation. So we don't see frivolous lawsuits. The cases that we do see are cases involving serious issues of significant concern. And whether the case is won or lost by the plaintiff, there's meaningful guidance that comes out of it. And actually, when we've counted up the number of cases, there are cases at the lower administrative level, but the number of cases that actually make it into the courts in the 3 Green Amendment states, less than 10 a year. So we don't see an onslaught of litigation. If we did see an onslaught of serious litigation in a state, it would mean there was a really big problem there. And thank goodness we have a Green Amendment. So that's number 2. Number 3, we hear that, well, this is taking the power away from the legislature and giving it to the courts. This is not taking power away from the state legislature. It's ensuring that the legislature has critical guidance, as Kacy talked about, to ensure that when they are governing, they are doing so following the rules of the road that we, the people, have laid out for them, ensuring that they are protecting the human inalienable right to a clean, safe, and healthy environment. But they still have that authority. They just now have better guidance on how to utilize it. In terms of giving the power to the courts, look, in our system of democracy, there is a key role for the courts. We have a legislative branch, an executive branch, and a judicial branch. And the courts always get involved to help ensure that our constitutions and our laws are being properly and faithfully interpreted and applied. Inclusion of the courts is part of our democratic system. And I actually would suggest that taking the position that there is no role for the courts when it comes to environmental rights is in and of itself an un-American statement. And then the final thing, which is pretty short and simple, that we've heard emerging over the last year and a half, is that the Green Amendment, if it's passed, is going to result in unintended consequences. Now, the speaker never defines what unintended consequences are. They just say unintended consequences. And somehow this is a big, scary thing that's now entered the room. For those of us who are advancing Green Amendments, whether it's me or the activists in all the wonderful states I'm working in, the response is always, yeah. We hope there'll be unintended consequences, because there'll be good consequences for the environment, for our communities, for environmental justice, and for climate justice. So we look forward to those good unintended consequences. We haven't seen any negative unintended consequences in Pennsylvania, Montana, or New York State.
Thank you for that, Maya. And Kacy, what are your thoughts on kind of common themes that you're maybe seeing out there?
Sure. So yeah, from my perspective, as a litigator in a state that does have a Green Amendment in Pennsylvania, we've seen kind of, as the Green Amendment exists, the arguments are either to limit it or kind of flip it around to kind of mean the opposite of what it actually does mean. So, for example, in terms of limiting, a lot of times litigants will argue, well, this statute already carries out Article 1, Section 27. So the agency that is, implementing the statute has nothing to, it doesn't even have to think about Article 1, Section 27. Or they'll say, it's a similar argument, but the agency will say the Green Amendment can't override our statutory instructions. We can only do what the statute says we can do, which, that is administrative law. That's how agencies work. But every statute that an agency has includes some wiggle room for that agency to make decisions on a case-by-case basis and use their discretion, which is, of course, where also other laws, including the Constitution, come in. An interesting argument that we saw in Pennsylvania, speaking of fracking in Pennsylvania, was there's a regional authority called the Delaware River Basin Commission that recently banned fracking within the Delaware River Basin, which includes New York, New Jersey, Pennsylvania, and Delaware. Some legislators from Pennsylvania and a couple of municipalities challenged that ban in federal court, and their argument for why they had standing to challenge that ban was because they were trustees. As you may remember, the Pennsylvania Green Amendment has that trustee language. And they were saying, as trustees, they need to be able to, kind of exploit these resources, the natural gas, the public natural resources, in order to grow the corpus of the trust, as if it was like a monetary trust that needed to be, added to with money. But the truth is that the trust is not, the environmental trust is not valued as a monetary item. It's the values are those rights that are protected as a result of maintaining the public natural resources. So fortunately, they did not win that argument, went up to the Third Circuit, and the court found that they did not have standing based on that theory. But it was an interesting way of trying to articulate their role under the Pennsylvania Green Amendment. So yeah, I think that's an example kind of what we've seen on the ground after an environmental rights provision is enacted.
That's very enlightening as to how Pennsylvania sees its role as trustee, as if it's like you said, a bank that has a fiduciary responsibility, as if the environment is some sort of money generating. And I understand the fiscal, kind of benefits of environmental resources, but to try to shoehorn kind of that kind of argument into the Environmental Rights Amendment, Pennsylvania is an interesting approach. I'll say that much. Kacy, thank you for that. So I do want to take this time to acknowledge that we are approaching the 60-minute mark. I do think in the website for registration, we put a disclaimer that we might go over a few minutes. So I do want to respect everyone's time and let everyone know that we probably are going to ask a handful of more questions to the panel and maybe go over by 10 or 12 minutes. But this is just one of those moments just to let you know that, we are at an hour, but we're going to keep going to the extent that, our panelists will have us. So on that, I do have a question for Ivonne. We know there's other states, as I opened up with my opening, there are other states where climate activists and young people are bringing in climate-based lawsuits and legal actions. How do we know how those cases are playing out? And is there something is there a larger movement growing right now with respect to green amendments?
Sure, thank you. Yes, over the years, there have been similar cases in multiple other jurisdictions, youth climate litigation, seeking rulings on environmental rights in states like Oregon, New Mexico, Washington, Virginia. But because the plain language, constitutional language in those states gives the authority to the state to define the rights those cases have generally been lost on motions to dismiss, primarily due to lack of standing, meaning those plaintiffs were not able to establish the required 3 elements of injury, causation, and redressability, meaning the court is able to direct a specific relief. What made the difference with the case in Montana, the health case, as we heard from Professor Gerrard, is that in Montana's constitution, there is a Green Amendment. And in fact, as we heard, it has had one since 1972. In Montana's constitution, the state is not only directed to protect the right to a clean and healthful environment, but those rights are also placed, as Maya explained to us, in the Declaration of Rights, meaning they are fundamental inherent rights and akin to freedom or liberty. So what that means is that those rights belong to the people. And that's why, as we heard, that case, the whole case, played out differently with a favorable outcome for those young plaintiffs. A good example on point is the state of Hawaii. There is currently a youth climate action in the state of Hawaii being advanced against the Department of Transportation in Hawaii. But Hawaii does not have a Green Amendment. The constitutional language in Hawaii also leaves it up to the legislature to define how to interpret environmental protections. That is the fundamental flaw, because again, that means that the environmental protections or rights do not belong to the people in Hawaii. What the state of Hawaii does have is that key trustee language that we heard from Maya and Kacy, as we see in Pennsylvania, for example. And that means that the state is a trustee of the public natural resources. As such, the state has an obligation to protect those natural resources for generations to come. That trustee language has proven to be effective and is a key component in that type of litigation. So that Hawaii case is likely to succeed. The reason why the state of Hawaii still needs a Green Amendment is precisely because that individual rights language is missing. And that's the focus of the movement, to ensure that those inherent rights actually belong to the state, to the people of the state of Hawaii.
Thank you for that, Ivonne. I'm going to pivot now to a question that's, again, I like to put the panel a bit of a hot seat. Maya, I'm going to ask you to put on your fortune-telling cap on, and would you tell us in your thoughts, how will the Held versus Montana decision, impact other states? Your organization, Green Amendments for the Generations, is boots on the ground on this movement. What are you, when you saw this decision, what did you think for states that are close to getting a Green Amendment in a referendum or a ballot? Did this get you excited? Did you get concerned? Give us your thoughts on that.
So of course I was very, very excited. And I did travel to Montana and sit in the courtroom for the entire trial. And it was very impressive how the attorneys put the case on and how the youth activists really represented themselves and their right to a clean and healthful environment. And so I expected, because Montana had Green Amendment language, I expected victory. And I was very, very happy when I saw it happen. We're already experiencing some of the benefits of the Held v. Montana case. First off, for the states where Green Amendments have already been put forth, look, getting a constitutional amendment in any state, right, is an extra hurdle. It's it's harder than legislation, but that's one of the benefits. It's harder to get, but once you get it, it has very broad, powerful ramifications, and you're unlikely to ever use it. And so for those states where there's already Green Amendment language that's been advanced, it was really inspiring and exciting for those activists working on those Green Amendments to see the value, the potential future value of their work, because many of them are doing it because of climate or environmental justice issues, as well as, of course, critical areas with regards to water, air, and ecosystems. Also, I think that the outcome of this case really is helping to strengthen a message that I've been delivering for many years, which is if we want Green Amendments to apply to the climate, We should explicitly say that people have a right to pure water, clean air, safe climate, and healthy environments. That the state has the duty to protect the natural resources, including the climate, for present and future generations. Don't leave it to the sort of the vagaries of the system and hope that a judge agrees with you that a healthy environment should include the climate. Just say it in the proposed Green Amendment language. And so actually most modern day Green Amendment proposals explicitly include the climate. And that way we avoid the expense and the time of having to make the case and prove the point and bringing forth the experts to make clear that the climate crisis is infringing on the environmental rights of the people, because we've explicitly said it includes climate. So it's just confirmation of the importance of adding that language so you can avoid the multiple days and expenses of having to prove that point in court. The Held v. Montana victory has brought a lot of people who were not aware of the Green Amendment movement. It's brought them to the movement. That's exciting. So I've already had 4 additional states contact me since the victory, saying, how do we make it happen in this state? And that's some of the reason for the yellow states that you saw on the map. But there are actually 2 or 3 additional ones that I didn't yet put up there because they're not yet right. And then in terms of states that have green amendments, I think neither Pennsylvania nor Montana nor New York explicitly mention climate, but this incredible victory in Held, I think, is going to help ensure that New York and Pennsylvania are also interpreted as having the climate as being part of the environmental rights of the people. In New York, absolutely, I think it's pretty clear, because New York's language is clean water and air and healthful environment. So that's similar language to Montana. So that the precedent set there's going to be really powerful for that similar language in New York. In Pennsylvania, it's healthy, talks about the natural qualities of the environment, and it approaches it a little bit differently. But I think also that the Held victory is going to be really powerful, persuasive precedent in Pennsylvania to encourage any future interpretation to include the climate as part of the environmental rights of the people of Pennsylvania.
Maya, your energy with respect to this topic is contagious, and I hope anyone listening is just getting fired up hearing how excited you are about just the possibility that we might be at the cusp of something big as a result of this decision. Pamela in the chat, Pamela, and I can't see your name, last name D, sorry, asked a really great question that I think is something worth posing to Kacy and maybe to Ivonne. So Kacy, Pennsylvania has a green amendment in its constitution. Can citizens use it as a basis to sue utilities that are not transitioning to clean energy? Kacy, do you have any thoughts on this, seeing as your boots on the ground in Pennsylvania?
Yeah, well, I don't have a lot of experience with state utility regulation, but to the extent that the PUC, for example, the Pennsylvania Utility Commission, is involved in these types of things, then yes, the Green Amendment does play a role, because as long as there's state authorization and regulation involved, there's room for, or there's an obligation for the state entity to make those decisions in a environmentally progressive and friendly manner. And especially when it comes to utilities, I think that's a lot of times where that kind of intergenerational aspect comes in, because you're thinking of long-term decisions, right? A lot of utilities, once they build infrastructure, it's there for decades and decades. So, one of the problems that we see on a national level in my federal natural gas work is that a lot of these pipelines and other natural gas infrastructure, they're being built now because of, an allegedly urgent need for increased gas supply. But then, these things are authorized to be in operation for 20 years. And even if they're authorized for about 20 years, they can go for 50 years. What are we going to do in 50 years with all of this fossil fuel infrastructure that has, authorization to operate at this certain capacity? So I think that when it comes to these types of long-term planning decisions, that's where that intergenerational aspect of a Green Amendment really comes into play.
Thanks, Kacy. And Ivonne, on a point with respect to kind of public, suits versus private, environmental lawsuits, I know utilities sometimes utilities, have it both ways in a sense where many of them can be privately owned companies, but then they serve a public interest, so they're regulated as public entities sometimes. But Ivonne, do you have any thoughts on that, on how the Green Amendment, case in Montana could be used to boost private environmental lawsuits?
Sure. I mean, I think just along the lines of what Kacy was saying, I think whether the regulation is the utility or any other type of state statute that concerns environmental protection, it's going to be governed, and the state has the same obligation to protect the natural resources, to ensure that the permitting or siting of projects going forward takes all those considerations and keeps the communities in mind and natural resources in mind, any new clean energy projects. It's all intertwined. So regardless of which entity is regulating or what is being regulated, it has to follow the constitutional mandate regardless. They just cannot avoid it. And it's like, for example, in the instance of Montana, the state can no longer ignore or not comply with the ruling. The court ruling held these statutes were unconstitutional, and that means they no longer exist. So with that in mind, any other state statute that attempts to even have that same effect is going to be scrutinized, and it's likely going to be challenged as unconstitutional going forward.
Well put, Ivonne. So
Jose, I just wanted to contribute quickly. I thought Kacy did a really great job at speaking to the specific utility question, and Ivonne as well. So I'm not speaking to the specific question, but I did want people to know that on the resources page of the forthegenerations.org website, whenever there's a good case that it really informs how a green amendment should be interpreted and applied, I try to write it up. And so you can go to the resources page and find many write-ups. And what you'll find in the Pennsylvania write-ups is there are actually two cases. Again, it doesn't speak exactly to the scenario, in the question in the chat, I think it was Pamela, but it does speak to the fact that the Green Amendment does in fact apply to public utility commissions. And there were two situations, one having to do with a power line, one having to do with approval of an LNG transfer station, where the Green Amendment was actually utilized in defense of the community against the proposed project because the Public Utility Commission failed to properly interpret, apply, and consider the Pennsylvania Green Amendment. So again, not exactly on topic, but is proving the point that the PUC is subject to the mandates of the Green Amendment because, of course, they are part of the system of governance in the Commonwealth of Pennsylvania.
Thanks, Maya. I'm going to use my moderator discretion here, and because we could speak about this probably for another 4 hours. But I think I want to give all of our panelists an opportunity to say maybe one final word on this, and then we'll wrap up so people can get back to their afternoon activities. So Ivonne, do you have any final words on this? And Maya, we'll end with you.
Yes, absolutely. Join the movement. Maya is a powerhouse. What she has accomplished is, I think, unheard of. And so please, anyone who is listening, please spread the word. The Green Amendments are valuable. The Green Amendments make sense and are absolutely needed now more than ever. And it is very easy to join, contribute, ideas. Buy her book. It's $10 with the coupon. So please, anything you can do. If everyone put their 2 cents, it will help exponentially. And this is how we get big things done. Thank you.
Thank you.
Extreme pleasure to be here today.
Thank you, Ivonne. And Kacy?
I think, my message would just be to kind of be heartened by this victory and enjoy it. And, a lot of times Green Amendments give me a lot of hope, and I'm not a naturally very hopeful person, especially as someone who hears about environmental issues and gets faced with a lot of decisions by government again and again that are disappointing and disheartening. I think you know, the beautiful thing about a green amendment is it gives us hope that things are going to be done differently in the future, and things can be done differently, and we have, as the people, have the opportunity to make that difference happen.
Fantastic. The message of hope. I'm deep into rewatching the Star Wars series for about the 18th time. So I'm back on my hope train. Thank you, Kacy, for reminding us. Professor Gerrard?
So we have in this decision evidence, proof that climate change stands up in the crucible of cross-examination. We still see climate denial in various political places, in various news media. This morning, in fact, Pope Francis issued an important statement saying how horrible climate denial is. There's never been a court decision in the world that goes along with climate denial, that doesn't acknowledge climate change. This decision from Judge Seeley is in many ways the strongest such statement, because it follows a trial and cross-examination. But it's very heartening that we have this, and we should work very hard to try to spread the word and go against the climate denial that some parties still have and that is so destructive.
Thank you for that, Professor. And you're absolutely right. It's inspiring to see the way that this is playing out and moving. So thank you for that. And Maya, I'll leave final words with you.
Great. Well, I want to thank everybody for their inspirational words. I've been inspired, and I've been inspired by all the people who have joined in the great conversation in the chat. You know, I've been an environmental activist and attorney for 30 years now, and I have experienced all the myriad of ways that our government officials and our laws fundamentally fail us and do put industry and profits and their own personal political agendas ahead of environmental protection and the people and future generations, right? And it can be so devastating when it happens. But I have also experienced firsthand the power of having a constitutional green amendment in the courtroom, but also as part of your advocacy, stepping up to that podium. I just did it at the beginning of this week and beginning the testimony with, I have a right, and then laying out what your constitutional entitlement is in a green amendment. It changes the nature of the conversation. It changes sort of the electricity in the room, how government officials listen to you, the power that you have. It changes the way activists view themselves intellectually and emotionally, because now they're fighting for the environment they love. They're fighting for the communities they love, but they're also fighting for their constitutional right to a clean, safe, and healthy environment. So I just think this is amongst the most powerful, important things we need to do to address the climate crisis, environmental justice, generational protection, and environmental protection across the nation. We need to do all the things that we're already doing. This does not displace that or replace that. But this will give us the most powerful legal tool available in the United States of America, our state and federal constitutions, and put it to work for our environment and for our people. And I just think that's inspirational and powerful. And I thank all of my fellow panelists for joining and for your powerful words, and for everybody who's joined in the chat. Many of the people who attended today are activists in some of our most powerful Green Amendment movements. So I thank you all for all your great work and activism as well.
Thank you, Maya. For thegenerations.org, check out Maya, buy her books, follow her on LinkedIn, YouTube, do it all, get inspired, motivate people. Maya, thank you. You're a national treasure, as I've told you in the past. And I can't wait to see you next time we get together.